rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. I am Chief Justice Amy Blake. To my right is Justice Vicki Henry. To my left is Justice Rachel Hirschfang. We are the panel for the 6 cases that will be heard today in this session. I know most of you have been here before, but a couple of reminders. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your materials, so our suggestion is that you get right to your argument. We will hear the first 3 cases and then take a brief morning recess. As you may have heard from the court officers, at the start of the 4th case, the courtroom will be briefly closed, and so other than the parties on case 4, no one will be in the courtroom for about 5 minutes. After a preliminary hearing, we will then reopen the courtroom, and the remainder of the cases are welcome to come back into the courtroom. With that said, we will start with our first case of the day, Commonwealth versus Markinson Lafleur, docket number 25P758. Ms. Quinn Judge, good morning.
Good morning. May it please the court. My name is Emma Quinn Judge. I represent the defendant Markinson Lafleur. I'm here to ask that you reverse the order vacating the stay of his sentence. As you know, based on the Commonwealth's closing argument, the trial court did some very unusual things. The trial court invited a motion to stay. Before sentencing Mr. Lafleur, the trial court, in fact, stayed the sentence. And then after the single justice vacated that stay, the trial court made additional findings on the record that there had been improper burden shifting, appeals to jury sympathy, and that, in his view, sympathy had likely affected the jury verdict in this case. Now, I know that when we...
though? So let's say I agreed with you on the merits. Can you get to the security risk question? Because I think that's a more difficult argument for you.
Certainly. I'm happy to start there. Obviously, on the security risk question, it's an abuse of discretion standard in terms of the single justice's decision. And I think what we have here is a situation that is very similar to the situation that was apparent in Nash, where the single justice just gave very little weight to the other factors. And in fact, looking at the single justice decision, there's one paragraph on the security factors. And that paragraph starts with 2 sentences saying, the defendant asserts this, the defendant represents this. Those are the references to the other security factors. And then the only factor that he seems to give any true weight to, the factor that is dispositive that his sentence turns on, is the serious and violent nature of the crimes for which the defendant has been convicted and the lengthy prison sentence as a result. And I know the Commonwealth tries to draw a little daylight between sentence and conviction, but here where there's a mandatory minimum, I would suggest that those are one and the same thing because the sentence flows directly from the conviction.
And what is the mandatory minimum?
10 years.
That doesn't present a flight risk?
Mr. Lafleur was out not only during the pendency of this case, but he was out from the day of his conviction up through his sentencing as well for an additional several weeks. So at that point, he had been convicted. He knew he was facing this mandatory minimum. There are a range of other factors that this court considers seriously that are not addressed other than in passing to say that the defendant asserts them in terms of the security risk factors. You know, the case law, Charles, for example, which was one of the COVID cases, talks about the fact that these are significant considerations: the defendant's familial status, roots in the community, employment, prior criminal record, general attitude, and demeanor. And so
can we consider those, or are we just limited in reviewing what the single justice did?
I think in considering whether the single justice abused his discretion, you would have to look at the entire range of security risk factors, how the single justice weighed or considered them, whether he in fact considered all of the security risk factors in making his decision.
Well, so, I mean, on that point, though, the defendant has school-age children, and I'm presuming I hope they have friends. Does that pose a security risk?
There was no assertion that I am aware of that there was any concern with respect to the defendant's school-age children, and in fact, the fact of those school-age children is yet another indication that he has roots in the community. I don't understand there to have been any argument, for example, that that was a security risk.
Well, and a security risk in terms of their friends?
The defendant was on GPS. I mean, there were a whole range of other restrictions on him. I don't understand there to have been any argument that that presented an additional risk. That certainly wasn't an argument that was made by the Commonwealth at the motion to stay argument before the judge or in the single justice briefing.
What about the risk of him working in a restaurant and potentially coming into contact with a number of people from the public that are completely unsuspecting?
I think, again, his steady employment history was seen as a positive rather than a negative in the context of this case. It's just not clear to me that any of those were reviewed by the single justice or considered by the single justice. There's no explanation for how he weighed those or didn't weigh those. There's a limited record, frankly, that he was looking at. And while the case law is not explicit on this, there is some discussion in Hodge of the fact that where the trial court is the person making these security risk determinations, and the trial court just has access to a whole lot more information, there should be some degree of deference or consideration given to what the trial court has said about the security risk. The case law here that applies Nash and analyzes security risk has a much more thorough look at security risk in those other situations. Pinney, for example, this was a 9 to 10 year case. He was convicted of manslaughter. And what was looked at there was family and roots out of state, insufficient mechanisms to monitor his behavior and secure presence, the fact that substance abuse was part of the underlying offense, and there was a concern that out of state that could not be carefully monitored. In Kalila, again applying Nash, you looked at dual citizenship.
Pinney was unpublished, right?
Pinney was unpublished. Kalila, SJC, applying Nash, you have a discussion of dual citizenship, recurring trips abroad, the impulsive, racially motivated and violent acts, a lack of credibility at trial. In the Springfield Railway case, there were specific findings made about the defendant's conduct during trial that were the basis for dismissing the security risk factor. Here you just don't have any findings other than the fact of the conviction and the fact of the crime of conviction.
But so going back to Judge Blake's question, the chief, I think, is saying, well, I'm not going to put words in the chief's mouth.
You can.
That, there is do you agree there's a difference between the potential you're going to be convicted and the reality that you were convicted and this 10-year sentence has to be imposed?
I think there is a difference between that, but I think it's the case law is clear that this is an individualized determination. And so when we only look at the crime of conviction, we are no longer conducting an individualized determination. At that point, instead of looking carefully at the different factors, you're just saying this person was convicted of something that's very serious. This person is convicted of something that faces a 10-year mandatory minimum. Therefore, they can't be let out. That doesn't seem like an individualized determination because it just doesn't.
Except that Commonwealth versus Springfield says at 228, a judge must find the defendant presents no risk of flight or danger. No risk, not minimal risk, but no risk. So we have 2 convictions, and I know there was some acquittals here. My memory is 2 convictions of aggravated rape of a child and 2 indecent A&Bs, or in that ballpark, with a 10-year mandatory minimum sentence. Tell me how no risk of flight facing that? That's where I get stuck.
Okay, it's 2 aggravated rape, 1 indecent A&B, but I don't think it makes a material difference for your purposes. Because here, he's under conditions, right? And that can be part of the analysis. His passport has been surrendered. He's under GPS monitoring. And so I think in terms of risk of flight, those are fairly significant conditions. If GPS monitoring and surrender of passport is not sufficient to ensure that there is no risk of flight, I'm not sure, I'm not sure what would be really, because those are fairly stringent conditions.
I don't mean to be flip, but, he wouldn't be the first person, if he did it, to cut off an ankle bracelet.
Yeah, but at that point, I think we are speculating about what he might or might not do. And this is somebody who not only showed up all the way through the case, showed up for sentencing, showed up for surrender, on the day, at the hour appointed in the trial court once the appellate wrangling had happened. There is no indication that this is somebody who is taking any steps to avoid, to flee, and I think we're sort of treading into the realm of the speculative and things that frankly aren't in the record, right? What we have in the record is that he showed up, that he has steady employment, that he has no criminal record, that he has strong family support, community ties, full compliance with all his pretrial conditions.
Was his defense at trial that it didn't happen?
I understand that to have been his defense. We're at a preliminary stage, so
Doesn't tell us that we can consider the strengths of the Commonwealth's case as well? Putting aside the alleged errors in the closing argument, and I understand that to be the thrust of Judge Wren's concern, in addition to the flight risk, we can look on the abuse of discretion question at the strength of the government's case.
Right. The strength of the government's case goes to the credibility of the
victims,
of the complaining witness, and I think that the questions about how the jury understood her credibility based on the closing argument really can't be separated, because
Well, but you have acquittals.
Right, you have acquittals.
Tells us something.
It tells you something, and I think in the ordinary case we say, oh, that's a jury sifting the facts carefully. Here what Judge Wren said is, that actually gives me more concern. I mean, he said that during the sentencing. I have more concern in a case that was entirely about whether the jury believed her.
Judge Wren, not Judge Brennan, right?
Judge Wren, yes. I don't think I misspoke, but it's close. I have more concern about whether there was an improper appeal to sympathy, whether there was something else going on in the jury, whether there was some prejudice to the defendant, because if you believed her on everything, and if you didn't believe her, you wouldn't believe her on some things. He had real concern based on that, and I think just because we often say in an appellate court that we can view this as sifting the evidence, I think when the trial judge is saying, no, in this case, on these facts, on the evidence I heard at trial, this actually gives me more pause and rather than less pause. I mean, that was the point at which he said, I'm not sure the curative instruction was effective.
What do we do with the language of Kalila at 111 that upheld the denial of the stay, where, quote, the judge acknowledged the defendant had complied with the conditions of pretrial release and had appeared for trial, but found that the conviction altered his incentives, which is essentially Ms. Lazar's argument?
I think what's different in Kalila is alongside all of that, you have extensive consideration of the fact that this was someone who regularly took his family abroad every summer. He had connections abroad. He was traveling regularly. He had dual citizenship. There were some comments, and I think the SJC had concerns about this, about his overall affluence and his ability to afford flight, frankly. But there was a lot of other evidence, and so just the fact that the conviction changed his incentives, I think goes back to my initial concern that you're imposing a categorical bar based on the crime of conviction, right? Once we're doing that, we're no longer doing an individualized assessment, and so I think all these other cases look at other things, and they look carefully at the individual defendant. Here, I would say that the trial court had the best information on the individual defendant had observed him for weeks, had observed him in pretrial, not for weeks, it was not that long a trial, I misspoke, for days, had observed him in pretrial proceedings, had observed him at sentencing, and as well as observing the family support that he had, was certainly aware that he had strong connections to the community and strong ties to the community, and had no concerns, whereas he had real concerns about the Commonwealth's closing and this sort of call to vindicate the victim and to give her a verdict to vindicate her credibility and things like that were said during the closing. So I think when you're doing the individualized determination, you have to look at all of those things. And going back to the single justice's decision, it's just not clear that he considered all those things. He doesn't say, I weighed these things in this way and I reached this determination. He just acknowledges that the defendant has made some assertions and proceeds.
So let's assume you're right, that he didn't weigh what he was supposed to weigh. What does the defendant, what's the order look like then?
Well, I think what the SJC did in Nash was that they, at that point, they found that the single justice had abused his discretion and reversed the single justice's decision vacating the stay. And so that's what I would be asking this court to do at this point. I mean, it could, at that point, could go back to the trial court. The trial court could either reissue the stay, presumably, or impose other conditions. But I think reversing the single justice's decision to vacate the stay is what we're asking for at this point.
So backing up to the other question, do you have any concerns that this test that the SJC is having us apply is not consistent? I mean, because Kalila says and the Commonwealth's brief is rife with this. On the one hand, there's this likelihood of success on appeal, that's one standard, but then there seems to arguably be a different, lower standard, and I'm not, where it says that the defendant needs to show at least one appellant issue of sufficient heft that would give an appellate court pause, and that burden is not onerous. Do you think those two things are the same thing?
I think it's all one standard. I think that when we shorthand it, we lose sight of how strong it is. I mean, what the standard was, if you go back to cases like Hodge in 1979, the standard is differentiating an appeal like this from a frivolous appeal. So you're saying this is a step better than a frivolous appeal, but it's certainly clear that you don't. I think that's where you get the not onerous, not that stringent. I think it is one consistent standard. I just think when you shorthand it as a reasonable possibility of success on the merits and only use that phrase out of context, it can sound different and it can sound more stringent than it is. But any case that explicates the standard in paragraphs or at length then goes on to say it's not onerous, it's not that hard. If we have things to talk about here, then certainly it's not a frivolous appeal, and certainly it's an appeal that should be taken seriously and would be enough for the defendant. On that issue, obviously, sorry.
So, I mean, there's a second piece to this where it seems like, arguably the courts are not being consistent here because, the Commonwealth Codes, Kalila is saying that the court, meaning the three of us, we don't substitute our judgment for that of the single justice simply because we would have reached a different result, and yet right now, the way the standard works is the single justice, which is just one of us, can substitute their judgment. In other words, they can just start a whole new analysis and not defer to the trial court. And I'm like, does that seem consistent and make sense to you?
And I just want to be clear, we're still talking about the first prong now.
Yeah.
Okay. I think on the first prong, and I was just looking at this again this morning, that Nash is, it's Kalila that says quite clearly that on the first prong, because it is a pure question of law, there is no deference given to the single justice's decision. And that this panel on the first prong is looking at that issue de novo as a pure question of law. It's only on the second standard where it is an abuse of discretion standard.
I see your time's expired, but let me just check with the panel. Seeing no other questions, we'll take the rest of the argument on your briefs. Attorney Lazar.
Good morning. Ellen Lazar for the Commonwealth. The Commonwealth asks this court to affirm the order of the single justice vacating a stay of the defendant's sentences pending appeal because the single justice correctly concluded that the defendant had not demonstrated a likelihood of success on appeal and correctly found that the defendant poses a security risk if released during the appeal.
I'm not convinced by your position on argument number one, so let's skip to argument number two. Your sister makes a compelling point that he complied pre-trial, he didn't flee after he was sentenced and stayed, and the security risk is the 10-year mandatory minimum. Do we have any, I know we don't have a lot of post-Nash jurisprudence, but do we have any case that's on fours with this one?
Yes, Your Honor. I think as some of the questions sort of implied or referred to, and the Commonwealth does argue in the brief that the defendant's circumstances have changed dramatically since pretrial. The defendant has now been convicted of 3 very serious crimes, 2 counts of aggravated rape of a child, 1 count of indecent assault and battery on a child, and sentenced to 2 10-year prison terms followed by probation. No credit whatsoever for time served. And I disagree that these are one and the same. This may be a mandatory minimum sentence, but there's still 2 separate factors that the courts say can be looked at. One is the severity of the crimes. The other is the length of the sentence. And
so if this was a drug case with a mandatory minimum versus a aggravated child rape case with a mandatory minimum, is that the distinction that you're making?
No, I just think the defendant is arguing that the Commonwealth is trying to say that those are 2 separate factors when in the defendant's view they're a single factor because the sentence was mandatory. And I disagree in the sense that regardless of whether the judge had the power to give a different sentence, this is what the sentences are. And the crime itself and the sentence are 2 different factors. And in any event, the defendant is facing 2 10-year prison terms for which he has been given no credit for time served. And in the Commonwealth's view and in the view of the cases cited, this does create a great incentive to flee. I think in Kalila, the court, definitely in the appeals court, Kalila, possibly also in the SJC, the court notes that this creates an incentive to flee and that the defendant's circumstances have changed. In Pinney, which I know is unpublished, but both the defendant and the Commonwealth cite, the court also noted that this pre-trial, there was an incentive to conform one's behavior to the requirements of the law in order to, in essence, present the defendant's best face to the court, but that the incentives have changed now that the defendant has been convicted. In addition, although I agree that Justice Brennan's discussion of all the factors was not lengthy, he certainly doesn't just completely ignore the facts that were presented by the defendant in mitigation. He does note that the defendant represents that he has no criminal record other than these charges. He's married with 3 school-age children. He's employed in a family-owned restaurant, monitored by GPS. But he says, nevertheless, he concludes that looking at all of the factors, in essence, those mitigating facts are outweighed by the gravity and seriousness of the charges, the sentences at issue, and implicitly, in my view, the danger to the public and the incentive to flee.
What about your sister's argument that given the kind of spareness of the single justice's ruling on this point, it is essentially creating a category of cases for which security risk is always going to be dispositive? I mean, as I compare, for example, Kalila and the findings that were made there on the security risk, those are much more robust findings than we have here. And I guess findings is the wrong word for the single justice review, but articulated reasons. Shouldn't there be more of a burden on the single justice to explain if in a situation where they're overruling the decision by the judge who actually saw the defendant at trial and imposed sentence?
Well, I don't view it as overruling the trial judge in the sense that Justice Brennan considered the question anew. So he was exercising his own discretion in weighing those factors. He wasn't commenting necessarily on what Judge Wren did. And the cases certainly don't say that there's any sort of a different burden when the single justice is quote unquote overruling what the trial judge did as opposed to agreeing what the trial judge did. I certainly agree that in some of the cases like Kalila, there's more discussion of what the factors were. But I think, again, that alone doesn't mean that the factors were not considered and weighed, as Justice Brennan shows that he doesn't simply say, these are serious crimes and a long sentence, period. He says, the defendant represents this, and this. Nevertheless, I find that the defendant has not shown that there is no security risk, which it is the defendant's burden to show by a preponderance of the evidence that there is no security risk, which includes security to the public and risk of flight. And so given that he clearly does acknowledge that there are these facts stated in mitigation, but he finds that those are outweighed by these other factors, I think that that's sufficient.
I don't think that last part, I was following you until then, but I think in light of what you said earlier in that same statement, would it be a more accurate phrasing to say, rather than that the judge didn't find that those sort of mitigating factors were outweighed, to say instead the judge found that the defendant had failed to establish, given those mitigating factors, that he did not pose a security risk?
Yes, I agree. That's a better way of saying it. Yes. And I think that literally is what he says. I conclude that the defendant has not established that he does not pose a security risk should his sentence continue to be stayed. So that is the finding that Justice Brennan made after considering all of the applicable factors.
So the defendant argues this was a pure credibility case. What do you say to that?
I agree that that the jury obviously had to sort out the credibility of the victim versus the defendant, where the victim said that these sexual assaults happened and the defendant said that they did not. I disagree in the sense that when the defendant says either the jury believed her or they didn't, and that's part of the reason that Judge Wren concluded that there was prejudice to the defendant in the split suggested by the split verdicts. I think the split verdicts can actually be pretty reasonably explained by the fact that the first complaint witness corroborated only the 2 counts of aggravated rape of a child on which the jury convicted. And so I think, again, that the strength of the evidence is a factor as well that Justice Brennan could have considered, and that given that the victim was corroborated, at least as to those 2 convictions, that does make the evidence stronger as to those convictions, and also explain why this was not simply a credibility contest between the victim and the defendant.
What in the judge's curative instructions were different from the usual instructions?
Well, for one thing, the judge gave the curative instruction immediately after the closings and informed the jury, in essence, I'm going to give you these instructions right now before I give you my regular jury charge, which I think makes them stand out, because he then went on to give the regular jury charge where he then reiterated some of those things. And, excuse me, I know that when we filed the briefs, we didn't have transcripts yet, so I was only citing to the places in the recording, if I can try to match up. But I know, so when the judge gave his curative instruction, he explicitly instructed the jury not only things like closing arguments are not evidence and you'll get the instructions from me, but he explicitly said things like, to the extent that you heard anything different from the attorneys in their arguments, I instruct you to disregard that. And so while he did not single out any specific quote from the prosecutor's closing argument, he, again, gave this instruction immediately following the argument and said, these are the principles that will govern your deliberations, and to the extent you heard anything different in closing argument, I direct you to disregard that. And so I think that that differentiated that from just the typical jury charge.
He also said, we have the benefit of the transcripts, for which we thank you, because I was not looking forward to listening to all of that and trying to make my own transcript. Those days are over for me. But on Volume 3, page 168, the judge also instructed the jury, in addition, your burden isn't sending a message to anyone, which did respond to one of the objected to lines of argument.
Yes, he said you're simply holding the Commonwealth to that burden of proof based on the evidence.
So could you explain a case where a defendant could prove there was no risk of flight?
I think, again, this is something where it's reviewed for error of law or abuse of discretion, because it is something that is very fact-based. I don't know necessarily that I could come up with, a factual scenario that would definitively, as a matter of law, be proof of no risk of flight. I can only say that.
But that's where I'm confused a little on the standard, because if it's inherently fact-based and the single justice hasn't seen the defendant, hasn't had the parties before him or her or them, hasn't watched the trial come in, I just don't understand how the single justice is in a position to then engage in a de novo review.
Well, I think, again, because the question before the court as to that factor is whether Justice Brennan abused his discretion, and as the court is aware, that standard is, in essence, whether his decision is outside the range of reasonable alternatives, given the facts that were before him, then I would imagine that there are cases that are on one extreme or the other where the decision would be so unreasonable that the court could find that.
So how is this different? Is it, I think it was Nash, where, I guess I'm just trying to understand why one person convicted of aggravated rape could prove it and another person wouldn't prove it.
Well, in Nash, the SJC said that the single justice had, in essence, really just focused on the crime and nothing more than that.
Okay.
It's the Commonwealth's position here that it was not only the crime, it was the crime, it was the 10-year prison sentences awaiting the defendant with no credit for time served. And again, even though I agree that the discussion was brief, Justice Brennan does note that the defendant is making these representations, but in essence, that those representations alone don't satisfy the defendant's burden of proving that there is no risk. If the court has no further questions, I would rest on my brief.
I see no other questions. We'll take the rest of the argument on your brief. Counsel, I want to thank you both for excellent briefs and excellent argument. The case is now under advisement. Our next case is Commonwealth versus Donald J. Conley, docket number 24P1367. As counsel approaches, just a reminder that it's partially impounded under the sealing statute, although I don't expect that issue to come up today. Attorney DiMaria, when you are ready.
Thank you. Good morning, Your Honors. May it please the Court. This case asks whether a man asleep in the back seat of a car who refused to move it when asked can be convicted of operating under the influence. No witness saw Mr.
But here's the problem. And neither one of you gave us a 16L. The SJC decided Wurzburger out of this court and answered your question, and the answer is yes.
Your Honor, and I apologize for the
Why don't we have a 16L? I'm going to ask Mr. Catalano as well. You both know better.
I set up a LexisNexis tracking. I noted for the court that it was under review.
It hasn't come out online yet. It's only out in
There's these things called books.
Okay,
I know, online books, it's crazy, but Wurzburger was decided and it doesn't help you.
I think it does, Your Honor. In Wurzburger, they clearly used the word once, and this is on page 6. Let me read the entire quote.
Go ahead.
Evidence of operation is sufficient once an individual in the driver's seat of a vehicle intentionally performs any acts such as turning the ignition key. If the court accepts that Mr. Connolly was in the back seat, Wurzburger is absolutely wonderful for me.
I don't think that's quite right. I mean, I love your enthusiasm. But the SJC also said at the end of Wurzburger, the jury could reasonably infer that the defendant intentionally turned the key. I know we're dealing with a fob with Mr. Connolly, so just pretend there's, put that aside. A mechanical step that, quote, alone or in sequence will set in motion the motive power of the vehicle. That sounds old because it's from 1928. And so I don't think there's any dispute on this record. Well, you tell me if I'm wrong. Was there any indication that someone else might have turned on your client's car?
Your Honor, it's the Commonwealth's burden to prove that he himself turned it on, but not just that he turned it on, but he turned it on while intoxicated. So if he was not intoxicated, he turns the car on, goes to the back seat, drinks in the back seat, falls asleep. Under Wurzburger, that is not sufficient.
I don't think that's right. I mean, I think if he's intoxicated in the car and it's on, I think under Wurzburger, he's out of luck.
I respectfully disagree. I'll draw the court's attention to another quote.
Are you in the SJC Wurzburger or the appeals court Wurzburger?
The SJC.
Okay.
Your Honor, on the last page, The statute seeks to deter individuals who have been drinking intoxicating liquor from getting into their vehicles except as passengers. Now, that's actually a quote from Severity, but it's on the last page, third last paragraph. And so clearly you can get in, pursuant to this decision, into a car while intoxicated as a passenger. And I will note, I really like Lillane as well. That was one of my cases. And Lillane basically says the same thing, and I would like to read the court two paragraphs, if I may. The first one from Commonwealth versus Lillane, there being an intoxicated owner of a vehicle immediately next to her car, wanting to drive it, despite it being inoperable due to a bent tire, is not sufficient to prove beyond a reasonable doubt that she operated the vehicle while intoxicated, in the absence of any evidence as to when the car was most recently operated or by whom. And in Lillane, this court also said that basically in every case, in Manning, in Peterson, there's always proof of recent operation. And I will also note that, again, relying on the fact that there's just no evidence that he was impaired at the time he turned the key. So I think Wurzburger is wonderful for me, and that the court is bound by that decision.
Well, isn't there a factual problem here? We look at the evidence in light most favorable to the Commonwealth, right?
We do, Your Honor.
Okay, and so on page 60, the question was, and the person they were speaking to, was that the man who was driving the car? And the answer is correct. Now, I realize that the question is what said man driving the car, but the witness, by saying correct, doesn't he adopt that?
So, of course, Your Honor, a question by counsel is not evidence, and I get what you're saying. He did say...
But he said correct.
Shortly before that, he did state, in his own words, that he did not make any observations of Mr. Connolly in the car. That's shortly before it, and so I think that trumps an improper leading question that we should not take as evidence.
But we're
What
not weighing,
language?
Sorry, Justice Henry.
What you said shortly before that, what language are you pointing to?
The words, make any observation.
Right, where is that in the transcript?
I don't have the pin site, Your Honor, but it's shortly before then. I do reference it in my reply brief as well, I believe.
But didn't your client testify at 105, 106 that the vehicle was running so the AC would work?
Yes, Your Honor, but if he's in the back seat and it's running and we don't...
Is there anybody else in the car?
There was not, Your Honor.
Reasonable inference, light most favorable.
I don't think it's a reasonable inference. He could have just as easily turned the car on while not intoxicated and drank in the back seat.
But then he's still in a running car, drunk. I think under Wurzburger, that's enough when there's no one else there.
Wurzburger, Your Honor, clearly says in the driver's seat, and they clearly use that other passenger language. I also referred the court to, and even another quote from Wurzburger, which is from McGilvery, even an intoxicated person who was sleeping behind the wheel. The problem is he was not behind the wheel, he was in the back seat. And I will say, too, in Wurzburger, as Your Honor will recall, the man was in a big vehicle. I believe it may have been a U-Haul. He's parked really close to a tree. He has a back issue. He can't climb over. So logically, if he has to urinate or do anything, he needs to pull out or pull forward to get out. In Mr. Connolly's case, if you accept that he's in the back seat, he just does not have easy access. He'd have to open the back door, get out, walk to the front door, open that door, get in, and so on. And in terms, Your Honor asked if there's proof anyone else drove it, the Commonwealth never established that the driver's seat was in a position consistent with his height or anything of that sort.
Well, but I mean, he said he had been living in his car, so presumably the driver's seat, the position of the driver's seat, I mean, it may or may not have been positioned for him to drive it, right? I'm not sure that's...
Oh, I meant perhaps it was for someone much, much shorter than, we couldn't for, hey, it was a much shorter person or someone different driving it. In Peterson, the position of the driver's seat was a factor. And
So
I
I'm just back factually, I just think you have a problem. I think the language you're relying on is on page 65. It's after the other question, but the question is, did you make any observation of the defendant in his vehicle when you knocked on the window? And he says the first time, question mark, no, I did not. But even accepting that, he testifies that he thought that the defendant was waiting for a parking spot, and it seems to me the jury would infer from that that the defendant was in the driver's seat, because one does not usually wait for a parking spot while you're sitting in the back seat of your own vehicle.
I respectfully disagree, Your Honor.
I mean, you're totally right. The Commonwealth needs a little retraining here in terms of proving the elements of the case, but why can't the jury infer from that he was in, I mean, and he's honking at the other car. Like, why would you honk at a car that has no driver in the driver's seat? Like, I mean, if they were at the trunk, I could get it, but like, if they're just passed out in the back, I'm not following it.
The way I visualize it is he was facing forward in his car. Maybe I'm mistaken. And well, he did say he wanted to back out, so he was facing forward. So you're assuming, respectfully, Your Honor, that he either from turning his head got a good view or through his rear view mirror got a good view.
Backup camera. Yeah.
So I really think that the Commonwealth is asking us to pile inference on inference and to speculate. And the fact that Mr. Connolly testified and no one, there certainly has to be retraining. He testified, the other gentleman was never asked, which window did you tap on? Where was he sitting? And I do think that we should not throw them a lifeline. They could have easily asked all these questions. And I will say one issue my brother may raise is the officer testified at page 73. I asked him, where he was drinking at. He said he was in Lawrence. He was having difficulty understanding, answering the questions. I just want to be clear that when he said, where he was drinking at, he said he was in Lawrence. Those are two separate things. The officer didn't say he said he was drinking in Lawrence, so I don't want the court to infer that he drove intoxicated from Lawrence to this parking lot.
Do you want to briefly address the Commonwealth's argument that this is an unpreserved claim?
Yes, Your Honor. Under Rule 25, it does not matter, is my view. The trial judge could have also done it.
Right, there were two motions for required findings?
Yes, Your Honor. And what's notable here, too, is that defense counsel filed written motions, and I put the exact language in my reply brief, and the written motions were very broadly worded, that there was insufficient evidence, though my understanding is that you don't even need to give a reason for required finding. Anything is sufficient. And the cases the Commonwealth cited, one had to do with the motion to suppress, and the other one, it seems, even though it was unpreserved, this court still reviewed it under Lattimore. And so I urge the court to follow Lane, which is a Rule 23, and to follow my reading of Wutzberger. And if the court would like, I'm happy to provide a Rule 6.
We have it. We
Okay.
have the case, so you don't need to do that.
If there are no further questions, I rest on my brief.
Judge Henry? We are all set. Thank you very much. We'll
Thank
take
you.
the rest of the argument on the briefs. Attorney Padalano, when you're ready.
Good morning, Your Honors. Assistant District Attorney Matthew Padalano on behalf of the Commonwealth. Your Honors, my apologies for the lack of the 16L letter. I try and make a habit of reading these when they come in. For whatever reason, this one escaped my view, but I am happy to address it here. Your Honors,
But you're familiar with it to discuss it today?
Yes.
Okay.
And I think a key issue, right, is that the car was turned on. We both agree to that. And the defendant tries to make the argument that it's unclear whether or not he was intoxicated at the time it was turned on. The element of intoxication was stipulated to at trial, which relieved the Commonwealth of its burden to prove intoxication in this case. And I believe that Wutzberger is essentially outcome dispositive now that we have it. It essentially says that if you have the car turned on and the element of intoxication is proven, then you have met your burden.
Does it matter where the defendant is seated in the vehicle?
I think that the seating in the vehicle is good evidence of operation, but it is not necessary to prove operation. I mean, there's many high-tech electric vehicles nowadays, and there could be all sorts of situations in which you don't have to sit in the driver's seat anymore to operate a vehicle. And in this instance, I think being in the driver's seat is good evidence that you have turned on the car and that you are the individual who did turn on the car. But if you have other evidence that shows that you operated the vehicle by turning on the car inside the vehicle, and I think that distinction is...
But what if you're in the back seat and you have one of those remote starts and you turn on the car because you want the air conditioning? You never were in the front seat, you just were in the back seat.
Sure.
Is that operation?
I believe it is because in Mary, and I think many other cases, they describe what operation is as a action that starts the sequence of turning the car into a moving vehicle. And turning the car while you're inside of it is the first step in that sequence. And for that reason, I believe that that situation would be sufficient. Now, there's an alternative argument of you have a key fob and you're inside the house, right, and you turn on the car. I think that would be much more attenuated to say that that is the beginning of a sequence to turn on the car, but that's not the case before this court. The case before this court is the evidence before the jury was that the car was turned on, the defendant was in the car, and the element of intoxication was not an issue before the jury because that element had been taken away from the Commonwealth's burden.
Do you think in the light most favorable to the Commonwealth that the evidence is established that the defendant was in the driver's seat?
My argument is that it is. I think under Wurzburger it's less needed to show that, but the evidence of the witness testifying was that he walked up to the glass, he tapped on the glass where the individual was, and that he identified, as the testimony that you pointed out, that the individual was the driver of the vehicle. I think those two read in concert.
Is his answer correct, sufficient to adopt that the defendant was the driver?
Yes, I think there's many situations in which prosecutors ask questions and the witness says yes or no, and that almost always is evidence. I can't imagine a reason why it wouldn't be.
I know why he stipulated to intoxication in light of the BT, but if he hadn't and we didn't have the BT, so we had the same facts, would the Commonwealth have had to shown that he was intoxicated at the time that the police arrived at the scene?
They would have to show that he was intoxicated at the time of operation, which I think because there's a busy car show, because he's parked in a way that would block other cars, there's a fair inference that he had recently parked. Additionally, where I understand that there's multiple interpretations of the officer's testimony, a reasonable interpretation of that testimony is that he had been drinking in Lawrence before coming to Andover, which would imply that the drinking occurred prior to the operation. And I think that is a reasonable inference that the defendant had operated the vehicle while intoxicated. But again, the element at issue here is operation, not intoxication.
So under Wurzburger, and I've gone back to Usky again, what is your position on your brother's argument that if, let's say he turned on the car when he was stone cold sober, and then, for the sake of argument, got in the back seat and drank. So the car is running, he's in it, he's intoxicated. Is that operation?
I don't believe it would be, solely because in order to have operation, you need to have some action that you have done. And in that case, the action is the turning on of the vehicle. So in our position, you'd have to show that an operation occurred. And in that case, there's no actions being done that are operating the vehicle.
But the danger to the public is exactly the same. You have a drunk person in a car that's running.
Right. I think that it arguably should be a crime. I think it's the issue of the actus reus. And I concede that that's not the case before us. The evidence here is that he was the one who turned the car on, and the evidence here is that he did so after having drank in Lawrence.
Okay, so back on that. Did the officer really testify that the defendant said he was drinking in Lawrence? I think that's what you wrote in your brief, because the question was, and what else did you ask him? And the answer was, I asked him, where he was drinking at. He said he was in Lawrence. He was having difficulty understanding, answering the questions I was asking him. So that, at that point, answer seemed about as clear as mud.
It is difficult to weed out exactly what is happening in that testimony, but this is in the evidence, in the light most favorable to the Commonwealth, reasonable inferences. A reasonable interpretation of that testimony is that the officer asked, "Where had you been drinking?" And he said, "I was in Lawrence." And that seems to be an answer, a question and an
Except
answer.
he then says he was having difficulty understanding and answering the questions I was asking. So you're like, okay, well then, if he was having difficulty?
Yes, I think he is having difficulty in formulating a clear answer to the question that was before him, but the answer does somewhat answer the question of where had you been drinking. That would be our position. I understand that it requires an inference as to exactly what the answer is to the question, but I believe it's a reasonable inference to have made here. And again, I think that the evidence is clear that he had operated the vehicle by turning it on and by being in the parking lot, and that he had parked relatively recently because of the busyness of the car show. If there are no further questions on that, I would touch on the issue of the standard here. I think we both agree that the Lattimore standard applies. The issue of whether or not the objection was clear, or the,
But he did move for required finding in the nature of operation, if you will.
yeah, and before I get into it, I just want to be clear that I think that this is a difference without a distinction in this case, because the only,
That's the same.
the result is the same, because essentially the difference would be, do you view the evidence at the close of the Commonwealth's case or at the close of the defendant's case? All of the evidence that I've cited for sufficiency and that I've talked about today was in the Commonwealth's case, so I believe that the result is the same. That being said, the Commonwealth's position is that the specific issue and the specific facts of the issue were not before the judge such that it was not raised. I understand that the court might have issue with that, but that's our position. But it is essentially not outcome dispositive in this case. If there are no further questions, I would rest on my brief.
Well, I'm,
Sure.
I'm still back on the failure to prove where the defendant was sitting, which is really a basic question.
Okay.
And the Commonwealth never said, where was the defendant, or did you ever see the defendant in the driver's seat? And we could say, well, a reasonably smart attorney would have asked that, and they didn't ask that, so it must have been strategic, and so, we can infer he wasn't in the driver's seat. I think you're going to say, no, we don't do it that way, right? Because the alternative is we infer the attorney fell below the standard of a competent attorney, right?
Unfortunately, in this case, many ADAs are horribly overtaxed, and sometimes they don't always articulate the questions as clearly as they should. But in this case, the evidence was before the jury. Was he the driver? And they did say yes. And I think from that, there's a reasonable inference that meant he's the driver of the vehicle. I mean, in a different context, we would have no problem if you were on the highway and you said, was that person the driver of the vehicle? You'd have no problem saying, oh, that means he's in the driver's seat. That means he has his hands on the steering wheels. I think that you could ask 100 different ways, and this may not have been the clearest way to have done it, but it does put the information before the jury. And I'll ask, I understand that the court probably won't want it, but would the court like a 16L letter on that
You
case?
don't need it.
All right, understood. And I'd rest on my brief and ask that the court affirm the defendant's convictions.
Thank you very much. The case is under advisement. Our next case is Commonwealth versus Charles B. Price, docket number 25P109. Just a reminder that after this case, we'll be taking a brief morning recess, and we will be clearing the courtroom except for case 4 for a few moments, and then the courtroom will reopen when the court officers let you know. Attorney Oren, when you're ready.
Thank you very much. Good morning. Catherine Oren for Charles Price. The sole issue before the court in this case is whether Price's plea was even partly coerced. And we know for multiple reasons beyond Price's sworn statement that it was. Now, first, per Mattis, we know that the sentence he was facing, should he not forego all due process rights, was cruel and unusual punishment, offensive to Article 26. Now, cruel and unusual punishment is not just tough sentencing, forcing stressful decisions. To the contrary, it violates standards of decency, it offends basic human dignity, and it shocks the conscience. In fact, the sanction threatened here was tantamount to a death penalty.
Do you have a case applying Mattis in the plea context?
No, I don't. I mean, what the closest my brother found was Dingle, and that was a Fourth Amendment, and it was an Eighth Amendment case. So I do not have that. But what you can rely on is broad precedent, even partly coerced pleas, and the fact that the sentence here was not part, it takes it out of the broad body of precedent in our reporters, where courts have denied withdrawal, denied that there was any coercion. When it was tough but proportionate sentences, and it triggered fear in the defendant.
One thing that confuses me is your argument that the plea, in part, is your argument that the plea was involuntary because there's been a change in the law in sentencing?
No, the plea was involuntary because he was scared as hell by the fact that Michael Wood could make
Every defendant that pleaded guilty to a crime come in here and say that?
Oh, but here we know, though, that the
How do we know? Other
from,
than his
from the
affidavit.
SJC in Mattis, and the SJC reached back, all the way back to 1978. This is retroactive sentencing corrections ordered by our high court. Because it's not just now and going.
Not in the plea, though.
Right.
To
Well,
Justice
not in the
Hirschman's
plea. This
point.
is with respect to the sentence. And what the value of Mattis here is that it clarifies, this is not a normal plea withdrawal case where the fellow is arguing, I was scared of a lawful but proportionate sentence. That's not going to be deemed coercion. That's just tough, tough decision-making in very important context. But here, this is not
Does
that.
Mattis or Diachenko stand for the proposition that emerging adults lack the capacity to enter into a negotiated plea, particularly where we have here an affidavit that talks about how much counsel did explain to him in the context of making that decision?
No, what Mattis does, the other value of Mattis, is that it spotlights core psychological characteristics of teenagers.
No question.
I'm sorry?
No question, but we've got to put it in the context. You paint with a very broad brush on Mattis. We have to tie it to this case,
That's
and I
right.
don't have that connection.
Well, the connection that I would urge is that these core psychological characteristics that no one questions here, they illuminate matters that make teenager more susceptible to coercive pressures in the plea context. And what you can do is you can look at the fact that this is cruel and unusual sentencing. It's not legal, but proportionate sentencing. Not
When
just-
you say this, you mean the sentence that he might have faced after trial,
That's correct. That's correct.
not the
And-
sentence that he actually negotiated through
Well,
his
no,
plea.
I mean, he basically, just to have a chance at parole, he gave all of his due process rights away, because otherwise, he knew perfectly well. It's not that he's not making a competency argument. What he's saying is that he was scared to death that Michael Wood could make self-serving joint venture claims, and he could easily die in prison, should jurors believe them. And it's not an idle fear. If police and prosecutors believe Michael Wood, there is a live possibility that fact finders at trial would too.
So
And
I just want to make sure, though, I understand your argument. You're saying that, and this ties into what the chief said, you're saying in this case, he made a decision because he was being faced with what is now determined to be an unlawful sentence, right?
It was an unlawful sentence back then, as the SJC has stressed, and that's why it has ordered decades of retroactive sentencing
Okay,
corrections.
and are you also, okay, and if that's the case, then what the chief said is true, which is anyone in this age category who entered a plea would be in the same position. I don't understand why there would be any distinction.
If they were coerced. And of course, it's a factual and logical possibility that
You're
Charles...
saying the coercion was the illegal sentence.
It is an illegal,
Is there
it's
extra
cruel and
coercion?
unusual
Yeah,
punishment.
but right, but that applies to everybody. Is there any extra coercion in this case?
Well, just the fact that he knew that Michael Wood had every reason, every incentive to go out there and repeat this claim in front of...
That's just the strength of the evidence, which is a normal and in fact encouraged consideration for defendants when they're trying to determine whether to exercise their right to a jury trial or negotiate a plea.
And the whole point is that had he not been threatened with cruel and unusual punishment, he would have gone. The no plea. Had he not been intellectually and emotionally overborne, no pleas would have entered. He had viable defenses. He had eyewitnesses. He had impeachment. And he had proof of incentivized claims. But he was terrified that should jurors believe Michael Wood, he would die in prison.
What was his negotiated sentence?
It was second degree with the possibility of parole after 15.
And is he, I assume he's out?
Yes, he was paroled. That's correct.
When was he paroled?
I can't really tell you that. He's been out. So
And this is his fourth, well, there
On my
may
count.
have been more, but fourth motion to withdraw a plea. Is this the first post-Mattis motion to withdraw?
yes, it is.
And
Yes,
first post-Diachenko?
yes, it is. Yes, it is.
And let's talk a little bit about Chisholm, because I think Chisholm hurts you, and that's the most recent pronouncement by the SJC on this topic, isn't it?
Well, that's a bit confusing because Chisholm is just a supplemental jury instruction case. It really doesn't reach coercion at all. And further,
Well,
it does.
so I'm going to push back, because Chisholm, I think, talks about Mattis and Diachenko in the context of the intent to commit murder and sort of what happens in the moment at the scene of the crime, which can be very spontaneous and instantaneous, versus a deliberate, thoughtful decision about whether or not to plead out or not with the advice of counsel, where in the moment at the scene of a crime, you're not consulting with counsel, should I shoot this guy or not, right? So I think Chisholm makes that distinction, and I think your brother refers to it as the courtroom versus the crime scene. Can you speak to that?
Well, I mean, what Chisholm confirms is that evidence about developmental psychology, neuroscience, specific to juveniles and emerging adults, that's entirely admissible and relevant evidence. And what Chisholm really says is that because Mattis and Diachenko are limited to sentencing issues, any differential treatment with respect to jury instruction problems, that's not affected by those cases. And here, Price is not looking for any differential treatment. What he's saying is he's looking for the same relief anyone coerced out of his trial rights would be looking for. He's stressing Mattis, which clarifies that this was not a legal sentence. This was tantamount to a death penalty and shocking to the conscience. He was 18.
I apologize for not remembering this, but did you apply to the SJC for direct appellate review on the question of whether Mattis applies to a plea?
I did not. I did not.
Do you know if the SJC has this issue under, and I'm going to ask Mr. Lynn the same, under advisement on any case or
I have
in the
no
pipeline?
knowledge of anything like that. And I've been watching, just the announcements. So if that's true, I can honestly
I
say.
haven't seen an amicus announcement,
That's right.
but
That's correct.
I don't study them, so.
That's correct. That's correct. And so, basically, the threefold relevance of Mattis is that it clarifies this was not legal sentencing. It was shocking to the conscience. And it was shocking to the conscience. It was cruel and unusual punishment. Back in 1978, when an 18-year-old faced that very threat, and it clarifies core psychological characteristics of 18-year-olds, including Charles Price, that make them susceptible to coercive pressures in the plea context. And here, but for being intellectually and emotionally overloaded, the pleas would have entered. No pleas would have entered. And it's on those grounds that Charles Price is asking this court. If I could just say a few words about the trial court disposition. It doesn't mention Rule 30, it doesn't apply it, it doesn't consider cruel and unusual punishment, coercion, or whether justice may not have been done. when cruel and unusual punishment terrified a teenager into blanket abandonment of due process. So failing to apply Rule 30 standards, that's error. So too, rulings that are ungrounded in fact, and there are two. First, the fear that should the court allow withdrawal of a coerced plea here would trigger decades of plea withdrawal litigation. Now, it's a factual and logical possibility, as I've stressed. Price was not the only one coerced. But we have no precedent like that. It's part of the position, the jam that Charles Price is in. On one hand, he's not entitled to relief because there's no case like that, even post-Watson, Miller, and Diachenko. But on the other hand, if I do this, the gates will burst wide open. And there's no facts underpinning that. I can't deny it's a factual and logical possibility, but there's no actual history underpinning that concern. So floodgate fears or concerns here are reduced to factually groundless fear that aren't even relevant to Rule 30 analysis. And so too, the finding that should the court allow withdrawal of a coerced plea, there will be decades of attacks on competency grounds of verdicts won against emerging adults. And that's very confusing because, again, Price makes no competency argument, even about himself, much less about anyone else. And there's nothing in Mattis, nothing in Price's argument that would suggest blanket incompetency of people under the age of 21. And so you have three separate errors there.
And are you really arguing the opposite? He made a very rational decision?
No, I'm saying he was scared into
Right,
it.
but you're saying I think what you're saying is that he made a very rational decision given the illegal sentence that he faced.
I'm not saying he made any rational decision. I have the evidence from Charles Price himself. He was terrified. He couldn't process it. The fact that Michael Wood could just say something to get out from under, and it was clear he was the one who was trying the door. He was going to go in the back, and had he been able to steal something out of the back while the victim was distracted, the robbery would have had taken place that way. And so, no, I don't say that. I say that Charles Price, under oath in his affidavit, I was scared to death, and 18 years old, and yes, he didn't have full ability to process causality and process future consequences of decision-making. He lacked full emotional maturity that helps with dispassionate assessment of plea alternatives. He was more easily rattled into giving away his rights, in emotionally arousing circumstances, hot cognition, but it reduced impulse control as well, plus enhanced susceptibility to peer pressure, including knowledge that both Wood and Struble had pleaded. And so that's the threefold relevance of Mattis for this court's consideration. And Price asks the court, given the fact that the trial court disposition doesn't apply the correct standard of review and repeatedly grounds in no actual facts, there's plenty of room here to correct the trial court, and Price is requesting that relief now.
Thank you very much.
Thank you.
Attorney Lynn.
Good morning, Your Honors. May it please the Court, Paul Lynn for the Commonwealth. The Commonwealth has cited both Brady and Dingell for the proposition that the fact that a sentence to which a person who pled guilty was trying to avoid later learns that that sentence has been declared unconstitutional does not affect the legality or the voluntariness of a plea, and that's the situation we have here.
What are the two cases?
It's Brady and Dingell. I cite them both in my brief.
Yes.
And as recently as 2019 in Commonwealth versus Wentworth, the SJC ruled that fear of a harsher penalty does not render a plea involuntary. There's no evidence
I want to be clear, because this doesn't seem like a harsh penalty is the situation. The situation is an illegal unconstitutional sentence. And are you saying that Brady and Dingle control in that particular circumstance?
Correct. Both of those cases involved sentences that were later deemed unconstitutional.
So I want to ask you, I mean, I know I asked opposing counsel this question, and the trial or the motion judge talked about, I'm going to reframe it as sort of a floodgate that would occur. That's not a proper consideration for us, right? We're looking at this case on these facts and whether or not Mattis applies in the plea context.
Correct.
Okay.
Go ahead.
Are you aware, particularly out of the office that you come from, of whether or not this issue of the application of Mattis is percolating somewhere else, either on this floor or the second floor?
I have not heard it from my colleagues. I've not heard it from anyone elsewhere. I haven't seen any publicity about it. As far as I know, this is the only case that is bringing up this issue.
Why wouldn't we apply Mattis in the plea context?
Well, first of all, as the court held in Chisholm, the Supreme Judicial Court held in Chisholm, Mattis applies only to sentencing. It does not apply to the elements of the crime. So here you have a case in which the defendant's sentence undeniably was perfectly legal under the law at the time, under the law now. There's no question that he is not entitled to be resentenced in this case. And there's simply no, to rule that it also applies to a plea where you're dealing, first of all, with cool cognition. There's no evidence the defendant has cited that Mattis is wrong in that respect, but there's hot cognition and cool cognition, and that was fleshed out. The evidence regarding those two ideas were fleshed out at length in the hearings on Mattis and Robinson. And the court came to that conclusion, and my sister has not cited any evidence that that is incorrect.
So you say something at page 16 of your brief. You say, the defendant received something invaluable in return for his plea that his contemporaries convicted of first-degree murder lacked, hope for release. And you cite Graham for that proposition,
Correct.
Which is a federal case. Are there any Massachusetts cases for that proposition that you're aware of? I didn't see any.
I'm not sure if there's any cases that have directly applied that, but it's a fundamental principle of the voluntariness of a plea.
And it doesn't necessarily matter, but do you know how long he's been out?
I do not, Your Honor. If there are further questions, I will take them, but otherwise the Commonwealth will rely on its brief.
I don't see any.
Thank you.
Thank you both. It's a very interesting issue. The matter is now under advisement. We are now going to take about a 10-minute recess or so. I'm going to ask that the parties that are in the courtroom on case 4 remain close by and in the courtroom. The parties that are here on cases 5 and 6, I'm going to ask you to step out until Chief Court Officer Smith tells you you can return to the session. We are in a brief recess.
All rise.